Okay, test, test, test. Let's see what we have. Should be live on Facebook. Posted up a comment. And should be live on YouTube Live. Oh, YouTube Live, I guess I have to press another button. There I am. All right, can you folks on YouTube see me, hear me? Audio check. All right, I got sound on. There's about a 25-second delay on YouTube, their system. Sorry. Okay, up on YouTube, up on Facebook. Thank you all for joining me. I really appreciate it. I hope you all had safe and happy and merry holidays and got all the presents you wanted. I'm pleased to say I got a bunch of gun stuff. Looking forward to getting back into competitive shooting again this year for the first time in probably a decade. So for the first time in my life, I actually got some competitive shooting gear for USPSA, looking at the carry optics, but got myself a production type holster and Velcro belt rig and the fancy mag pouches and all that jazz. So looking forward to that. Last shot USPSA probably about 15 years ago. Always just with my carry gear. But now I'm going to have a little bit of competition gear. I'll still be shooting my carry gun. My SIG 320 compact with the RMR is my carry gun, and it's what I'll be using in USPSA carry optics. I'll be using the same gun in IDPA, except I'll take the slide with the RMR off, and I have a slide I've set up with Dawson Precision fiber optic sights that I guess are legal, hopefully, in IDPA. And I'll have an IDPA satisfactory holster and mag pouch set up. So hopefully I'll be shooting a lot of both of those, which as a corollary to that means I won't be traveling as much. So if, the number of live classes I'll be doing next year is going to be driven down, folks. We're going to be quite aggressive about that. The good news is we're able to replace most of that now with our DVD set. So I'll talk about that a little more in a moment. All right, we're right at 12:01, so let me get through some housekeeping before we dive into the merits of things. Of course, we do these Law of Self-Defense live Q&A sessions every Wednesday at this time, most every Wednesday. We skipped last Wednesday because of the holidays. I apologize for that. We do these at 2 p.m. Eastern Time, noon Mountain Time. They last about half an hour. We talk a little bit about some recent self-defense cases that have come through the court system, a little bit about some legal principles involved in self-defense law, and then I'll take whatever questions you guys have either sent in beforehand or post up on the comments section on either Facebook or YouTube Live. We'd appreciate it, obviously, if we could get even more people watching, so please feel free to tell your friends about it. It's pretty easy. Wednesdays, 2 p.m. Eastern Time, either facebook.com/law of self-defense or youtube.com/law of self-defense. We'll get them there, I believe. And, of course, any of you can keep up to date on our newest products, services, events, appearances if you subscribe to our e-newsletter. You can do that at lawofselfdefense.com/newsletter. We do ask for your email. Obviously, we need your email to send you an e-newsletter, but we never share emails with anybody, so you needn't be concerned about that. I mentioned our DVD products. We're hoping to displace a lot of my travel with that. Last year, I traveled over 40 weekends of the year, folks. It's just too much. So what we've done is we've produced a Law of Self-Defense Level 1 class DVD set. It's a 4-disc DVD set. It's actually more content than our live class because we don't have the time constraints of a live class. It's a couple of hours of additional content. And it covers the generalized legal principles of the law of self-defense, illustrating those with statutes, cases, and jury instructions chosen from all over the country for illustrative purposes. And then we supplement that with state-specific DVD supplements. These are single DVD sets, 1 disc per state. And we have, I'm pleased to say, 22 states now done. In the last week, for those of you who thought I was taking off for the holidays, in the last week, we got 4 more state-specific DVD supplements done. Those are Michigan, Pennsylvania, Wisconsin, and Connecticut. And as part of the launch we do with any state-specific supplement for the first week after we launch it, we make it available at 50% off. So if you're interested in Michigan, Pennsylvania, Wisconsin, or Connecticut self-defense law at 50% off, so $49 instead of $99, the next week would be the time to get that. You can find out more about that at lawofselfdefense.com/DVD. As I say, we have 22 states done now. Those are California, Colorado, Connecticut, Florida, Georgia, Illinois, Kentucky, Louisiana, Massachusetts, Michigan, North Carolina, New Jersey, New York, Ohio, Oklahoma, Oregon, Pennsylvania, Tennessee, Texas, Virginia, Washington, and Wisconsin. And within the next week or two, I expect to have Alabama, Indiana, Minnesota, Missouri, New Hampshire, and West Virginia also completed. So, again, more about that at lawofselfdefense.com/DVD. Also, for any of you who are instructors, I know how difficult it can be to be an instructor and have to handle these crazy legal hypotheticals that your students throw at you. That's why we offer our Law of Self-Defense instructor program for instructors who'd like to learn this stuff themselves at a high level. But alternatively, rather than spend money to take the Law of Self-Defense instructor program, if you'd like to make money, you can always sign up as an affiliate with us and refer people to these Level 1 DVD classes to cover the self-defense law in a state-specific way, because we're close to having all 50 states done. We'll have them done, if not by shot, then shortly thereafter. And we have a very healthy revenue share for instructors who join that affiliate program, recommend these DVDs. So something for you to think about. Also, for any of you who are podcasters, we started experimenting the last couple of weeks of 2017 with a Law Self-Defense Case of the Week audio clip. It's about a 5-minute audio of me talking about some interesting appellate court decision involving self-defense law. We make those available to podcasters with a customized intro and exit for each particular podcast. We don't charge anything for this. Just plug it into your own podcast if that's of interest. We do have in the exit a customized promotion for that podcaster's affiliate page with us, so that people who listen to their show, to their podcast, they can click over to that affiliate page. If they're interested in buying some products, they get good information, we make a little money, and the podcaster makes a little money as well. So if either the instructor affiliate program or the podcaster affiliate program is of interest, just send an email to us at support@lawofselfdefense.com. Also, speaking of SHOT, I will be at SHOT this year, for better or for worse. I'll be there most of the week. I arrive on Monday, I leave on Friday, doing some promotional stuff for the Outdoor Channel with the Best Defense, doing a book signing over at the TI Outdoors Simulator booth, and various other things, meetings, all the things you do at SHOT. So if you see a guy walking around in a lawyer suit, say hello. That's probably me. I'll be glad to meet you in person, sign your book if you have one. I won't be selling anything there, but I imagine we might run some kind of SHOT show type promotion during that week while I'm out of the office. Okay, I think that's all the housekeeping. So, questions that came up this week. Actually, there was a couple of cases that were sent to me. One came through our Law of Self-Defense Instructor Program closed Facebook page, so that's limited just to people who've graduated from our instructor program. One of them sent me an interesting case about a self-defense case in which the defendant sought at trial to bring in an expert witness on use of force law. And the trial judge denied him the privilege of doing that. The trial judge did not allow the expert witness to appear, to testify. This defendant was convicted. did appeal his conviction, and that denial of the expert witness was one of the reasons for his appeal, a basis for the appeal. I don't want to get into the details of that case because the particular case isn't that interesting, but it raises the question of, well, why couldn't this defendant, or any one of us for that matter, be entitled to bring an expert witness to the stand? If you read the gun community type literature, the gun magazines, the forums, you might get the impression that you can bring a use of force expert to the witness stand if you feel like. It's entirely at your discretion. Just bring Masa Ayub or Marty Hayes or any of these guys, all of whom do fantastic work, by the way. Just simply decide that you want to bring them to the stand, pay them, or for those two particular guys, if you're part of the Armed Citizen Legal Defense Network, just call them. And they'll get on the witness stand and say all kinds of great stuff about your use of force in self-defense and impress the jury, et cetera, et cetera. The problem with that view is that, in fact, you don't have an absolute right to bring an expert witness to the witness stand. Expert witnesses serve very specific purposes in a court of law. We're all presumed to possess common knowledge, and jurors are all presumed to possess common knowledge. Knives are sharp, fire's hot, guns are dangerous, for example. Now, jurors are not expected to possess specialized knowledge. So if there is specialized knowledge that's relevant to the case, well, then you can argue the jury won't understand that. They haven't been exposed to that specialized knowledge. And one way to get that specialized knowledge in front of them is to bring in an expert witness, someone who has expertise on that specialized knowledge to talk about it. The trick is, it really does have to be specialized knowledge. It has to be something that's not common knowledge. If it's simply a subject, if the issue at stake is something involving common knowledge, there's no reason to bring an expert to the witness stand, and it's a common reason to get an expert denied. For example, if you're planning to bring an expert witness to the witness stand to talk about the fact that a large attacker is likely to be stronger than a smaller victim of that attack, the jury doesn't need an expert witness for that. If you want to talk about the fact that somebody who has considerable fighting expertise may represent more of a threat to a defender than somebody who doesn't have that fighting expertise, well, certainly evidence of that fighting expertise would be relevant, but you don't need the expert witness to testify to that. In fact, they wouldn't be in a position to do that. There's no reason the expert witness would have personal knowledge of the attacker's exceptional fighting ability. In any case, a jury knows that someone who does MMA or martial arts or any of a number of things, once they have that evidence in front of them, they don't need an expert witness to explain the relevance of that evidence to them. Now, there are areas of expert knowledge that they couldn't know, absent an expert witness, things like the Tueller drill, for example. The fact that somebody armed with an impact weapon can be a deadly force threat at a substantially greater distance than one might think if they weren't aware of the Tueller drill. Evidence about battered spouse syndrome would be another example where the evaluation of whether or not a threat is an imminent threat can be different for someone who's been subject to a long-term pattern of abuse than it might be for someone who has not been subject to that kind of pattern of abuse. So bringing in experts to testify about things like the Tueller drill or battered spouse syndrome, assuming those are relevant to the case at hand, is a more compelling case for bringing that expert witness to the stand. In other words, there's an apparent need for that person's expertise. The other question, of course, is do they actually possess the expertise? So they have to be able to qualify as an expert witness. Guys like Masa Ayub and Marty Hayes wouldn't have any difficulty doing that, but that doesn't mean that the guy teaching firearms instruction down the street would be able to qualify just because he read a magazine article about the Tueller drill, for example. The standard is likely to be higher than that. The other question, of course, now we have a need for the information. We have a qualified expert. Is the information itself qualified? Stuff like the Tueller drill is taught to every police department in the country. Battered spouse syndrome has been recognized by every court in the country. But that doesn't mean every facet of self-defense tactics has been widely recognized by law enforcement or trainers or courts. There's a lot of people teaching some weird stuff out there in the self-defense community. And if it can't be demonstrated to be widely accepted and demonstrably effective, then it doesn't matter if it might be relevant, or if you have a good expert, the information itself simply doesn't have the authority necessary for it to be admissible in front of a jury such that it could influence their decision making in arriving at a verdict. So don't ever assume that if you're in a self-defense shooting, you'll automatically be able to bring in an expert witness. That's not how it works. Certain specific conditions have to be met before that expert will be allowed. And by the way, whether those conditions have been met is almost entirely at the sole discretion of the trial judge. If that trial judge decides he doesn't want your expert to testify, your expert's not testifying. And it's almost impossible to appeal that decision. It's left within the trial judge's discretion, which has another consequence. It means your lawyer basically gets one shot at arguing for that witness. If he blows it and the trial judge decides against the witness, the discussion is over. So pretty important that your trial attorney make a compelling argument for that expert if that expert is in fact important to your defense. Okay, so that's expert witnesses. Let's take a moment to talk about circumstantial evidence. This came up in an inquiry I got from Rich Brown over at the American Warrior Society. There's a case, I forget now where it is, might be Minnesota or someplace, where a police officer shot a woman in the neighborhood for apparently no good reason whatever, and still he hasn't been brought up on any kind of charges. And when asked about this, the prosecutor is saying, well, we just don't have any real evidence. The problem is the investigators. They haven't given me any evidence to work with. And Rich raises the question of, well, what does this mean? I mean, does this mean that if there's a shooting between two people and there's no witnesses, as long as the shooter doesn't say a word, then there's no evidence on which he can be brought to trial? And the answer to that is no, that's not how it works. And I'm not sure where this prosecutor is coming from in this particular case. But what he seems to be saying is he doesn't have any direct evidence in order to bring charges against this police officer, which I think is a good segue into talking about the difference between direct evidence and circumstantial evidence. Direct evidence is evidence of a direct and personal nature of an event that's an issue in the case. So typically an eyewitness who observed a shooting, that's direct evidence about the shooting. Circumstantial evidence is not direct evidence. It's evidence from which an inference has to be made that somebody was involved in the shooting, for example. A lot of forensics evidence falls into this category. So there's a shooting, there's no eyewitnesses, one person's dead, somebody is seen running away, the cops grab him. Well, the fact that someone's running away doesn't mean they shot the person. Could it be circumstantial evidence that they were involved in the shooting? Perhaps. They do a gunshot residue test on the person's hand that comes back positive. Well, that's not direct evidence that they were involved in the shooting. They might have been shooting an IDPA match the day before. But is it circumstantial evidence that they might have been involved in the shooting? Absolutely. Consciousness of guilt evidence is classic circumstantial evidence. They lied to the police about what happened, demonstrably lie. The direct evidence is clearly inconsistent with their statement, or they themselves give inconsistent statements and internally contradictory statements. Classic form of consciousness of guilt evidence. Now, that's not proof that they shot someone, inconsistent statements, but it's circumstantial evidence from which one could make an inference that they shot someone. Now, when we watch police dramas or court dramas on TV or in the movies, whenever circumstantial evidence comes up, the characters always disparage it. Oh, all we have is circumstantial evidence, as if it's somehow inherently weaker than direct evidence. And that's just not the case. There's nothing wrong with circumstantial evidence. Circumstantial evidence can be just as compelling. It can be more compelling than direct evidence, especially if you have a lot of it and it's internally consistent with each other. So it's not hard to imagine, for example, a scenario in which you have two people enter a locked room. There's no other way in the room. The room's 8 by 8. There's a gun in the room. Two people enter. The door's locked. There's a gunshot. One guy walks out. The other person's shot dead inside the room. We have no direct evidence of what happened there, but we have circumstantial evidence, and there's no explanation for what occurred that's inconsistent with that circumstantial evidence. Now, set aside, the other guy might say, well, he shot himself. Maybe we need more circumstantial evidence. Maybe we need gunshot residue on the hands of the person who emerged from the room, or we need circumstantial evidence in the form of the gunshot wound was not of a nature that could have been acquired by self-infliction of the injury. So circumstantial evidence, nothing wrong with it. And by the way, direct evidence can often be extremely weak. We all know that eyewitness testimony, it is direct evidence, but that doesn't mean it's strong evidence. Eyewitnesses can be impeached. They might have motives for lying or fabricating their testimony. We all know that if you take 5 eyewitnesses to an event and you separate them, you get 5 variations of the story. So the notion that direct evidence is inherently stronger and circumstantial evidence is inherently weaker is simply not the case. What is true is with circumstantial evidence, you have to look at the evidence and then make inferences, reasonable inferences from that evidence. But we do that in courts all the time. That's simply a perfectly normal part of the fact-finding process for the jury. Okay, we got another question. I always get these questions about self-defense insurance programs, and I don't want to answer them every show. So I keep trying to make my answers shorter. There's a number of them out there that do a good job. I don't tend to recommend one over the other because they each have different baskets of products and services and price points. I don't know what would best fit anyone's needs. Frankly, whether you need insurance at all is a very personal question based on your risk tolerance, and I just can't make those decisions for people. There are a couple of types of insurance programs that I simply cannot recommend because of their inherent nature. And those are any insurance program that's largely or entirely a reimbursement if you're acquitted program. I cannot recommend because you don't need the money after you're acquitted. You need the money to get acquitted. The other type I don't recommend is any self-defense, quote-unquote, insurance program that limits the attorneys you can choose. In other words, either that guy has to represent you or there's a limited list of attorneys in his firm. They've contracted with the provider, whatever the case might be. So you can select from his list, but not from outside that list. I don't like those because there's a huge variation in quality of defense attorneys out there, as there is in any skilled profession. And you need to be able to pick an attorney you can have confidence in. You're going to be living with this guy. If you're involved in a killing charge, a murder or manslaughter charge, and you're raising self-defense, you're likely to be living with this attorney for a year or 18 months, and your life is in his hands. If he blows it and you get convicted, he doesn't go to jail, you go to jail. So you really have to have confidence in this person. And it's not clear to me that you'll necessarily have that confidence from an attorney that's chosen off a list that's provided to you. I can tell you in the case of the Zimmerman case, for example, Zimmerman's trial attorneys were Mark O'Mara and Don West, and they did a fantastic job. That was a perfect legal defense. They were awesome. But those were not the first attorneys Zimmerman had. He went through several attorneys before he ended up with that team. And if he'd been stuck with the first attorneys, I'm not sure the outcome would have been the same. So any plan that either reimburses you largely or entirely after the fact or limits the attorneys you can choose from, I do not recommend. Okay, so let's see what kind of questions we have from online. It's people saying nice things about the DVD program. Thank you very much. I really appreciate that. How do I choose which state to do for the next DVDs? That's a combination of a number of variables. One is if we've done a live class in the state already, and we have in most states, but not all states, then we've already done the legal research for that, so it's easier for me to start with those. But that's not the only factor. Another factor is how much interest we've had. People email us and ask about particular states. We keep track of that information. But we're pretty close to getting through all 50. We're crunching these out pretty hard. I canceled all my travel in December or January just so we could really catch up on all this stuff. So we don't promise dates on states, and I don't take pre-purchase, pre-available orders or money for these because I don't want to have to guarantee a particular date. But as I said, we're getting 3 or 4 out a week at this point, and we're working pretty hard on those. Am I affiliated with USCCA? Not anymore. For about a year and a half, I was a founder of their legal advisory board. I've left that legal advisory board. It just wasn't productive for me. Not much seemed to be happening. That said, I've consulted on cases for USCCA members in the past, all with very positive outcomes. I'm happy to do that in the future, but USCCA doesn't pick me or not pick me for those consulting roles. I'm selected by whoever the lead counsel is for that particular USCCA member. But no, I don't have any formal relationship. USCCA has, a couple of years ago, they licensed the third edition of my book. They put their own cover on it, and their CEO, Tim Schmidt, wrote a foreword for the book. I believe they're still selling that under that license, but that's about it. No, the lack of a Kansas DVD isn't because I have anything against the Wizard of Oz. I did have a not great experience riding my motorcycle across Kansas from east to west. That was not a terribly pleasant experience. But no, nothing personal against Kansas. We'll get to it as soon as we possibly can. Let's see what else. Any more substantive questions here? Someone asked about the level 2 classes. So when we do a live class, a level 1 class, we typically do that on a Saturday. And that covers 6 or 7 hours doing the legal principles of self-defense law, illustrated with snippets, a couple sentences, a few sentences from the relevant statute or court decision or jury instruction. We don't show an entire court decision because, well, they're 30 pages long. We couldn't fit it on a slide, and we just don't have the time for that in a level 1 class. But once someone's taken a level 1 class, they're eligible to take a level 2 class. We typically do those on a Sunday. And in the level 2 class, what we do is take the most important 10 or 15 use of force court decisions, appellate court decisions, the self-defense case law in that state. And the court decisions are where the rubber meets the road, folks. Statutes, it's important to understand, statutes by themselves have no effect in the real world. They don't have any effect in the real world until they're interpreted and applied by judges to real people in real cases. And it's not unusual for judges to interpret and apply statutes in ways that can seem contrary to the plain English language, plain English meaning of that statute. So statutes don't mean what the legislature hoped they would mean or the legislature intended they would mean. That would be nice, but that's not how the system works. Statutes mean what the judges interpreting and applying those statutes say they mean. And that happens in the appellate courts, the mid-level appellate courts and the Supreme Court of the particular state. So in a level 2 class, what we do is take the 10 or 15 most important appellate court decisions on self-defense law in that state, and we do what lawyers call brief them. We strip out all the legalese and we distill them down to their essential use of force elements, so you can see how the legal principles are being applied in the context of the statutes and the particular facts of that case. I have to say it's much more intensive on an intellectual level than a level 1 course. It's not going to be, I think many people might find it too dry and too boring. We make a major effort in the level 1 class to strip out all the legalese, but you really can't do that when you're briefing case law because the legalese is the case law. So we typically get about half as many students for a level 2 as we do for a level 1, but this is how lawyers themselves learn the law and understand how it's likely to be applied to their clients. We don't learn the law just by reading the statutes. The statutes are essential. It's a starting point. But if we want to understand how those statutes are likely to be applied to our clients, we read the case law. And that's what we cover in depth on the level 2 classes. The other part of that question is, do we have level 2 classes available on DVD? The answer is not yet, but we will. We're getting all the level 1 classes done for all 50 states first, all 50 states and probably DC. And then once all those are done, we'll start going through and developing the level 2 classes on DVD for each state as well. My thoughts on actually carrying an unserialized ghost gun. The truth is, it shouldn't matter. I mean, the gun, assuming the gun's legal, you made it yourself and you've met all the gun law requirements. And I don't claim any particular expertise in gun law, so I'll defer to others on where the threshold might be for the lawful building of such a gun. Carrying it on your person, I think it raises risks in terms of legal arguments that the prosecutor might try to make in front of the jury to suggest some form of malice on your part. It shouldn't matter. Whether or not your gun is serialized is not an element in a self-defense claim. But prosecutors make all kinds of arguments in front of a jury to make a defendant look bad that from a technical perspective don't have anything to do with self-defense. Famously in the George Zimmerman trial, one of the prosecutors, John Guy, made a big deal out of the fact that George Zimmerman was carrying his gun, a Kiltec, not a Keltec, a Kiltec 9mm with a round in the chamber in the ready-to-fire position. As if there was something wrong with that. It's tactically an idiotic point. Every bailiff in that courtroom had a round in the chamber. Everybody who's carrying a gun for personal protection has a round in the chamber, or at least I would hope so. And of course, it has nothing to do with self-defense per se. But the fact that those things are true doesn't mean the prosecutor can't talk about it in front of the jury to try to make the jury think there's something wrong with the defendant, that the defendant's not normal. He's behaving in some kind of abnormal fashion, some kind of fashion consistent with malice rather than self-defense. Might a prosecutor try to do that with the fact that you have an unserialized gun? And let's face it, ghost guns are not common. They're rare. So in that sense, it's not quote-unquote normal. It's something other than normal. Sure, a prosecutor might very well like to make that argument. Might your defense lawyer argue that he ought not to be able to make that argument? I certainly would. I don't think it's relevant to any point in the case. But judges often give great discretion to allowing these kinds of arguments in the courtroom, and then if they decide after the fact that the argument is somehow prejudicial, they'll instruct the jury not to pay any attention to that, which is, the horse is out of the barn by that point. The jury's heard it. If it's going to influence their perception of the defendant, that's already happened. Now, I'm not telling anyone not to do that. I mean, as long as it's lawful, you have to make your own decisions. To my mind, it's much the same as carrying your own loaded ammo or making certain modifications to how a gun fires, putting a lighter trigger in it. None of these are inherently fatal to a self-defense claim. In fact, most of them shouldn't be relevant to a self-defense claim. But nevertheless, they can be made to sound relevant, and it creates vulnerabilities in your defense of self-defense in court that I don't think need to be created. Now, if you're in circumstances where the only gun you could get or have for some reason is an unserialized gun, and it would be lawful for you to do that, well, I guess if that was my only option, I'd be carrying around an unserialized ghost gun. Again, assuming it would be lawful to do that. I don't have that constraint. I can carry around a totally normally gun. I do. So I avoid that in that way. Okay, let's see. Well, we are running up against the hour. Let me just take a quick look and see if there are any more. Somebody heard me on AMS today. I think that was probably AWS, American Warrior Society. Several people are mentioning Armed Citizen Legal Defense Network. They're a fine organization. They have a great board. Like all organizations, they have their advantages and disadvantages, but they are not among the ones I would not recommend. If you're considering self-defense insurance, I would certainly encourage you to take a strong look at Armed Citizen Legal Defense Network. I would also encourage you to take a look at USCCA and CCW Safe. And there are others out there that are good. I just can't list them all. I don't have great experience with every single one of these that are out there, and there's a whole bunch of them. Someone asked if we have a separate email for graduates from the class. They emailed Emily and didn't get a response. I would just try again. Sometimes emails go sideways. And if you can't get her, my email is the same, except it's Andrew. The suffix is the same, so feel free to contact me directly. Someone asks, in closing, does the prosecution have a better case over hollow point bullets? So this is exactly the kind of rhetorical argument that a prosecutor might seek to make. I don't think it's a very good argument. I think it's a very easy argument to counter. I certainly would not carry hollow point bullets. I carry them every day. I have for 25 years. Unless, of course, you live in some weird state like New Jersey in which it would be unlawful to carry them or perhaps even possess them. At least that's my understanding. Again, I don't claim great expertise in gun law. But might a prosecutor try to suggest that you had hollow point bullets in order to make a bigger hole in your attacker? Sure, he may be able to do that. Now, hollow point bullets, that brings us back to expert witnesses. I don't believe jurors would be expected to know anything about the terminal ballistics of a handgun round, and if they wouldn't, and the prosecutor makes that a issue in the case, then that would be a very solid foundation on which to bring in an expert witness to testify about the fact that hollow point bullets have a lot of well-intentioned advantages over jacketed bullets or lead bullets. And that's the reason that law enforcement agencies all over the country carry them. Not because those law enforcement agencies are full of malice, but because they are the appropriate choice for defense of persons. Okay, folks, well, I've been on about 35 minutes. I kept a few of you a little bit long. I apologize for that. For those who want to go, feel free. I do have for those who came a little late, I'll repeat the housekeeping comments I made at the start. So if you've already heard those, have a great week. I'll see you back next Wednesday. Tell your friends and family about the show, please, and encourage them to visit us at lawofselfdefense.com. And maybe our newsletter, lawofselfdefense.com/newsletter, so they can get more information from us. Okay, to repeat the housekeeping, on our state-specific DVD supplements, these are the state-specific supplements to our Law of Self-Defense Level 1 DVD class, the 4-DVD set. We supplement that with state-specific DVDs. We just finished 4 more: Michigan, Pennsylvania, Wisconsin, Connecticut. And for the next week, those are 50% off. So $49 instead of $99 as part of the launch of those DVDs. You can learn more about those and our 22 total state-specific DVDs at lawofselfdefense.com/DVD. If you're an instructor and you struggle, as I know most instructors do, with the crazy legal questions you get when you're teaching your classes, that's why we started our Law of Self-Defense Instructor Program, a very intensive program to bring instructors up to the level of what they would learn if they took a self-defense law class in law school, if any law school taught this stuff, which to my knowledge none of them do. But if you don't want to pay money to become an instructor, and the class does cost money, you could make money by recommending to your students that they take a look at the Law of Self-Defense Level 1 DVD class. Then they don't have to wait for a live class to come to town. They don't have to travel to some other location. They can just get the DVD sets, and we offer a very generous revenue share for instructors. We would set up an instructor affiliate account for you, a personalized landing page for you to send your students to, and whatever they buy through that landing page or the discount code we provide you gets credited to your affiliate account. And for podcasters, we just started doing a Law of Self-Defense Case of the Week audio clip. It's about a 5-minute audio clip on a recent interesting self-defense case that's come out of the appellate courts someplace. We make this available to be spliced into your own podcast. We don't charge for this. We do include an affiliate plug at the exit part of the audio clip. And by the way, the audio clip has a customized introduction and exit for every podcast. And that affiliate plug at the end simply directs people to your affiliate page at our website. So if they buy anything after having landed at that page, you get credited as an affiliate. You get your revenue share. Helps us get the word out about self-defense law generally and our products and services in particular. And everybody makes a little bit of money doing it. It costs the customer no extra at all. So if you're an instructor interested in an affiliate program, or the podcasters interested in that audio clip, no charge, 5 minutes, people are liking it, send us an email at support@lawofselfdefense.com. All right. Oh, and if you're going to be at SHOT, you see a guy walking around in a lawyer suit, say hello. That's probably going to be me. All right, folks, that's all I have for this week. I'll see you all again next Wednesday, January 10th, right here, either at Facebook Live or YouTube Live. Join our newsletter, and you'll get an email update about it. If you're on YouTube, you can click the little Remind Me button on the event as soon as we have it up. You can subscribe to our YouTube channel. That would be appreciated as well. And, of course, tell your friends and family about us. The more people that hear this, the more people we can put in a position to decisively defend themselves without simply putting themselves in a position of facing a lot of expense and jail time. Remember, You carry a gun, so you're hard to kill. Know the law, so you're hard to convict. Until next week, folks, take care. Bye.